About 2 hours ago, the United States Supreme Court met to hear the oral arguments in Biden versus Missouri and Becerra versus Louisiana. Those are the two mandate cases. Essentially, this is about the OSHA mandate for businesses of 100 employees or more. The Sixth Circuit and the Fifth Circuit, I believe it was, came to different decisions as to whether or not the OSHA mandate should be enjoined. So there's a split in the circuit. So the United States is divided into a number of judicial circuits. I'm in Georgia, so I'm in the 11th Circuit. That covers Alabama, Georgia, and Florida. In Louisiana, where the one case was filed, it's the Fifth Circuit, and the Fifth Circuit covers Texas, Louisiana, and Mississippi. And each circuit essentially in every state has district courts. And then those district courts, when you appeal, you go to the circuit. So in Georgia, if I'm in the middle district of Georgia, my court with an appeal to the 11th Circuit, and from the 11th Circuit, you go to the Supreme Court. So there are three levels. You have district court, we'll exclude magistrate bankruptcy for sake of argument here. You have a district court, you have a circuit court, you have the Supreme Court. Those are your three paths. So the district court, you appeal to your circuit court to the Supreme Court. In Louisiana, a case was filed in Louisiana, and a case was filed in Missouri. And those judges made decisions, and it was appealed to those respective circuits. And the Missouri Circuit, I think it's the 6th, don't hold me to it, ruled that the OSHA mandate was constitutional. The Fifth Circuit in Louisiana said it was unconstitutional. When the circuit split, that means that in Texas, Louisiana, and Mississippi, they're bound by the Fifth Circuit decision that it's unconstitutional. And all the states that are in the other circuit, including Missouri, are bound by that circuit. Well, when that happens, the Supreme Court is required to take the case to rectify it and settle what is the law of the entire land. So they rushed this. This was out of the ordinary hearing. They normally don't meet on Friday to hear these arguments anyway, but they had to make a special exception for this case. The issue is whether OSHA, the Occupational Safety and Health Administration, or whatever it stands for, is allowed constitutionally to require that employers of 100 or more do a vaccine mandate based on a congressional statute. That's the big issue, the rule. Now, what is the rule in particular? Under 1970 law, OSHA has the authority to issue emergency rules for workplace safety, provided it can show that workers are exposed to a grave danger and the rule is necessary. A grave danger and the rule is necessary. Now, you should know that there's precedent here, and Sonia Sotomayor in her argument today really undermined her own position. In the 1990s, there was a massive outbreak of hepatitis B. And OSHA prepared a rule to mandate vaccines for Hep B. They never did the mandate. There was a question over whether or not they had the authority to even do that. Congress passed a law ordering OSHA to do it. And that's the argument of the business interests here. The National Federation of Independent Businesses, NFIB, so one of the plaintiffs in this case, along with the states like Louisiana and Texas, Georgia, Brian Kemp and Chris Carr in Georgia, my governor, attorney general involved in this, Ron DeSantis down in Florida, and his attorney general also involved in it. The Louisiana attorney general and the Texas governor and attorney general all involved. And their argument is very simple. Because we have precedent here, Congress had to order OSHA to do the Hep vaccine. Congress should have to order OSHA to do the COVID vaccine because you can tell there is no emergency. How can you tell there is no emergency? Because the President of the United States ordered this done in October? To distract from Afghanistan? September, October, and it doesn't even go into effect until next week. If it's an emergency, how can the president order it in September or October and not have it go into effect until January? Additionally, we do know that there will be mass workers quitting at a time of labor shortages. We have, I told you the other day, the private sector employment growth from ADP looked good, but we actually have more economic numbers now, and it's actually bad. When you take into account the people who lost jobs, quit jobs, walked away from jobs, or died, and the new jobs, we did not hit the growth target that everyone predicted. It's actually far less than that. Only about 188,000 new jobs created in this country. That's actually a really bad number. They were looking for well over 250, it appears. So when you take into account that, and you take into account that the vaccine is going to cause people to quit, well, then you got a real problem. And then Sonia Sotomayor decided to open her mouth, the dim-witted Supreme Court justice, and she is, by the way. If you go back to the documents that were released during the Obama days from the National Archives and stuff that was leaked out, it turns out that even Latino law groups were advising the Obama administration not to put Sonia Sotomayor on the Supreme Court because she wasn't that smart. I'm not making that up, by the way. That came out. I am not making that up. Latino law groups urged them not to use Sonia Sotomayor because she's an idiot. She proved herself that yet again today. Listen to this. This is her from the Supreme Court. Rarely do you hear these things, but they released audio of this emergency hearing today. They let you listen to it live. Now, of course, I can't play the audio for some reason. Let's go. Here we go.
A year ago in January, we have hospitals that are almost at full capacity with people severely ill on ventilators. We have over 100,000 children, which we've never had before, in serious condition, and many on ventilators. So saying it's a different variant just underscores the fact that without country today than we had a year ago in January. We have hospitals that are almost at full capacity with people severely ill on ventilators. We have over 100,000 children, which we've never had before, in serious condition, and many on ventilators.
None of that is true. None of that is true. Hospitals are not at almost all full capacity. That's not true. There are not over 100,000 children in this country hospitalized or on ventilators. None of that is true. She asserted that as a justice of the Supreme Court to defend the OSHA vaccine mandate. And none of it is true. It's flat out not true. Not only that, she expressed that the Omicron variant is as deadly as the Delta variant. That too is not only not true, but even the New York Times is now reporting that the Omicron variant is not nearly as severe, even for the unvaccinated. That was one of the big issues to begin with is the Omicron variant just less severe for the vaccinated, or is it also less severe for the unvaccinated? It turns out it's less severe for everybody. More contagious, less severe overall. That's what the data now shows. She did not know that. She had no idea. Now, it's not her business to know that. It's her business to know the law. But part of her argument that she made from the bench was that OSHA should be allowed to impose the mandate because it's so bad out there. I find this deeply ironic in that it comes a day after liberals had their hair on fire over conservative ignorance of the rule of law. The question is not whether we should do something because there's a problem, but whether Congress has authorized an executive agency to do it. That should be the issue here. Yes, we all get that COVID is bad. We all get that people are getting it. We all get that the older you are, the worse off you can be. We all get that we're in the middle of a global pandemic, although not necessarily anymore. It's more endemic. But that's not the question for a judge. That's not the question for the law. If we're to respect the rule of law, as they all told us yesterday, then you need to respect whether or not there is a law that gives OSHA power. And I would believe no. And in fact, the majority of the justices on the court seemed highly skeptical that OSHA has the power to do this, particularly in light of the hepatitis B precedent, where Congress had to specifically authorize OSHA to give that vaccine mandate. Also, would there be immediate harm? That's one of the rules for an injunction. Would there be immediate harm unless the injunction is given? And the National Federation of Independent Businesses noted that based on regular surveys out there, you will have a massive amount of people who leave their jobs voluntarily or are fired because of their refusal to get this vaccine. There would be immediate economic harm in this country if this mandate went through. And by the way, is it an emergency when you've waited 4 months to implement it. Citibank has data out saying that hundreds of thousands of workers will be out of work next week if this mandate goes in. Hundreds of thousands of people in their job survey, I believe it was Citibank, will walk off the job if this mandate goes into effect. That's a pretty big negative consequence if you allow this mandate to go through. It's a pretty big consequence. So, in synopsis here, the Supreme Court justices, the majority of them, it sounds like, are not willing to let the mandate go through. They're willing to allow the injunction to hold while this is litigated. Now, this is one of the things you need to understand here. The purpose of the Supreme Court is not to rule whether or not this vaccine is or is not constitutional at the moment. That's not really what we're doing here. The question is, as I understand it, and I'm going to have to go in the commercial break to verify myself on this one. It's whether or not the injunction should stay, because you've got these two courts. They've rushed through whether or not the injunction should go forward. And one of the issues with an injunction is, will there be immediate harm, and does the preponderance of evidence show that the law is probably on your side? It's not a conclusion that the law is on your side, but whether or not the law is probably on your side, whether or not you've got a reasonable chance of winning. And the Fifth Circuit said there will be immediate harm, and you probably got a chance at winning this thing. You got a plausible argument. The Sixth Circuit said there's not going to be immediate harm, and you don't seem to have a plausible argument. So now the Supreme Court here is going to decide, do you have a reasonable shot at a plausible argument? And would there be immediate harm? Immediate harm is the biggest issue here. If, assuming they agree there is a plausible argument, is there going to be immediate harm? And we know from the Citibank survey and the like that there will be immediate harm. A lot of people will lose their jobs next week unless this injunction is allowed to continue. I would expect that the Supreme Court will rule on this sometime next week. The reason being, the injunction or the mandate begins enforcement next week, so they've got a rule on the injunction here in the next couple of days. And again, it's over whether OSHA can require employers with 100 people or more impose a vaccine mandate. Now, here's the other angle on this, just real quick before I go to break. You got to understand, is there was a divide in the arguments today over whether this is for the public at large or for employees. And I couldn't believe it, but the Biden administration was arguing this is for the safety of the public. Well, OSHA regulations are for the safety of employees, not the safety of the public. There's a nuance there. OSHA employees are about protecting workers on the job, not about protecting the public at large. That's the Federal Trade Commission. And this is an OSHA thing, so this is about employees. And that there was even that divide in the argument there was kind of mind-numbing. They should not have conceded that point. That undermines their argument. Sotomayor undermined her own argument by talking about the Hep B vaccine, and her argument was that OSHA drafted the Hep B mandate in the 1990s. The counter argument to that was, but they never implemented it. Congress passed a law saying implement this because OSHA was not clear whether or not it even had the authority to do it. And by Congress acting, they pretty much made it clear OSHA does not have the authority to implement a vaccine mandate. This should be a unanimous opinion from the Supreme Court that the injunction could stay in place because there is so much confusion, there would be irreparable harm, and there is a plausible argument for the plaintiffs. But you and I both know the liberals on the court are going to side with the government and do this, not because of what the law says, but because of what they want. And if the liberals on the Supreme Court can make the argument that we should do what we think is right, not what the law says, then why shouldn't the January 6 people who stormed into the Capitol do the same thing, to do what they think is right, not what the law actually says? We either all follow the rule of law or none of us do.